Good evening, everyone. Thank you for coming to the 2026 Orison S. Marden Moot Court Competition Final. My name is Sung-Hyun Shin, and along with Alicia Wu, we are this year's Moot Court Board Marden Executive Editors. We will begin tonight's competition with a word from the Dean of NYU Law, Dean Troy McKenzie.
Welcome, everyone. I will be brief because you don't care what I say, that you shouldn't care what I say today. But I'm delighted to welcome everyone to this year's Orison Marden Moot Court Competition Final Argument. This is the 54th year of Marden, which, of course, is one of the staple events of our calendar here at the law school. This is a moment for students to shine, to show their excellence in oral advocacy and legal writing. Just a quick word about who Orison S. Marden was. I didn't actually know this until I became dean and was forced to find this out. But he was an alum of NYU Law. He served as a trustee of the law school for 15 years. He was a practicing lawyer here at a major firm in New York. And he served as the president of both the City Bar and the New York State Bar Association. And he was also a president of the New York Legal Aid Society. So he was someone who was at the top of the profession, a supporter of the law school, and a great model for many of us. During this competition, of course, we have attorneys and judges who provide feedback and guidance in judging the various rounds of the competition. And this allows everyone, all of you, to hear and learn from them and also from your classmates. So before I say a word of congratulations and good luck to the finalists, I just want to thank our judicial panel, from whom we will hear in a moment. We are very, very pleased and fortunate to have with us three phenomenal members of the bench. From the D.C. Circuit, Judge J. Michelle Childs. From the Ninth Circuit, Judge Danielle Forrest. And from the Fifth Circuit, Judge Stephen Higginson. And I can't thank them enough for participating in Marden this year. And I will say, informally, each of them has complimented the Moot Court Board on putting together, as one of the members of the panel said, a really gnarly problem. So I think it'll be a great argument. And I really also want to thank the Moot Court Board leadership, your editor-in-chief, Emily Payne, executive editors, Sung-Hyun Shin and Alicia Wu, and the entire Marden masthead for truly terrific work this year. This is an example of just excellent work. And finally, the finalists. I want to take a moment to congratulate all of you on making it this far. Micah Musser, Anna Kolesh, Rosie Coffey, and Aidan Farmer. Congratulations and good luck. And this will be a fantastic argument.
Thank you, Dean McKenzie. Hi, everyone. Over the past year, Sung and I have had the pleasure of organizing Marden as your Moot Court Board Marden Executive Editors. We're super excited to be hosting the final round tonight. As the Dean mentioned, this is the 54th year of the Orison S. Marden Moot Court Competition. That's over half a century of exploring unsettled areas of law through rigorous student advocacy. Each year, Marden begins with some preliminary rounds. This past October, we hosted about 100 judges made up of local alumni, practitioners, some of whom are real judges, and of course, the MCV also helped out a bit. We had 61 competitors write briefs and perform oral arguments on a problem written by Moot Court Board Casebook staff editor Maya Shumra. Maya's problem contemplated whether the privately contracted medical staff of a state prison are eligible for qualified immunity in Section 1983 lawsuits. Later this evening, we'll be honoring some of our Fall Marden Award winners for their excellent advocacy. And based on some stellar work, we had 12 competitors advance to our semifinal rounds, which were hosted about 2 weeks ago. The spring competitors also wrote briefs and also performed oral arguments, but this time on a new problem written by Moot Court Board Casebook staff editor and managing editor Chris Afoha. Out of our 12 semifinalists, we are left with 4 competitors who advanced to finals tonight, and they will argue tonight on Chris's problem. Tonight's case arises from a multi-district litigation, or MDL, concerning PFAS contamination from a chemical facility operated by defendant corporation Harkonnen Industries. PFAS, as some of you may know, are forever chemicals that persist in the environment and have been linked to several serious diseases. Earlier litigation over this contamination produced several bellwether trials, which are test cases in MDLs where a few representative cases are tried before a jury, and 2 of these bellwether trials resulted in favorable verdicts for the plaintiffs. Those verdicts helped drive a large global settlement, but nevertheless, new claims continued to emerge against the defendant corporation. So tonight, we have a plaintiff, Mr. Paul Atreides, who alleges that exposure to PFAS caused him to develop ulcerative colitis. Instead of filing in his home state of New Caledonia, Mr. Atreides used a case management order that allowed plaintiffs to direct file their claims in the MDL court in the Southern District of Arrakis. When doing so, he did not designate a home forum, which the order permits him to do but doesn't require him to. Mr. Atreides moved for partial summary judgment and asked the court to preclude Harkonnen from relitigating issues such as duty, breach, and general causation because of the earlier bellwether verdicts. And the district court agreed with him and applied the law of New Caledonia, which allows offensive non-mutual issue preclusion. But the 14th Circuit reversed and held that the MDL court should apply the choice of law rules of the MDL Forum of Arrakis instead, rather than attempt to determine where the plaintiff would have filed absent the direct filing procedure. The court also held that applying issue preclusion based on bellwether trials without a finding that those trials were representative of the broader plaintiff pool would violate procedural due process. So we're left with 2 easy questions tonight. First, in a direct filed MDL case where no home forum is designated, whether courts should apply the choice of law rules of the MDL forum or the forum where the plaintiff likely would have filed instead. And second, whether the due process clause requires a finding that bellwether trials are representative before their judgments may be used to preclude a defendant from relitigating issues in subsequent MDL cases. I'll hand it over now to Sung to introduce our competitors and our judges, and thank you all for being here with us tonight.
Thank you, Alicia. We are thrilled to welcome our panel of judges for this evening. Judge Higginson from the 5th Circuit, Judge Forrest from the 9th Circuit, and Judge Childs from the DC Circuit. Judge Stephen Higginson has served on the U.S. Court of Appeals for the 5th Circuit since 2011. He currently serves as the presiding judge of the Foreign Intelligence Surveillance Court of Review after being designated by Chief Justice Roberts. Judge Higginson has also served on the Standing Committee for Federal Rules of Practice and Procedure. Judge Higginson received his bachelor's from Harvard College, his law degree from Yale Law School, and his master's of philosophy from the University of Cambridge. Judge Higginson has also served as a law clerk for the Honorable Patricia Wald of the DC Circuit and the Honorable Brian White of the Supreme Court of the United States. Judge Higginson was an assistant U.S. attorney for the District of Massachusetts and the Eastern District of Louisiana, and also taught at Loyola University New Orleans College of Law. Next, we are joined by Judge Danielle Forrest, who has served on the U.S. Court of Appeals for the 9th Circuit since 2019. Before joining the federal bench, Judge Forrest was a state trial judge in Oregon, where she served as the chief civil judge and the presiding judge. Judge Forrest holds her law degree from the University of Idaho College of Law. She has served as a law clerk for the Honorable Paul J. Kelly Jr. of the 10th Circuit, the Honorable Michael W. Mossman of the United States District Court for the District of Oregon, and Judge Diarmid O. Scanlon of the 9th Circuit. Judge Forrest practiced commercial litigation in Portland and has taught advanced civil procedure and litigation skills at Lewis and Clark Law School. And finally, we're joined by Judge J. Michelle Childs, who has served on the U.S. Court of Appeals for the D.C. Circuit since 2022. She previously served as a district court judge in the United States District Court for the District of South Carolina and as a South Carolina State Circuit Court judge, where she served as the chief administrative judge for General Sessions and as chief administrative judge for the state's business court. Judge Childs has also served as the Deputy Director for the South Carolina Department of Labor, Licensing and Regulations Division of Labor, and as a Commissioner on the South Carolina's Workers' Compensation Commission. Judge Childs holds her undergraduate degree in management from the University of South Florida Honors College, a law degree from the University of South Carolina School of Law, a master's in personnel and employment relations from the University of South Carolina's Darla Moore School of Business, a master's of judicial studies from Duke University School of Law, and an honorary doctorate degree in public service from the University of South Carolina. We are honored to be joined by this panel of judges today. Next, we want to welcome tonight's competitors, Micah Musser, Anna Kolash, Rosie Coffey, and Aiden Farmer. Micah Musser is a 3L from Lancaster, Pennsylvania. He graduated from Georgetown University with a degree in government and worked at a think tank in Washington, D.C., where he wrote on AI and cybersecurity policy before starting law school. Last summer, Micah was a summer associate at Cleary Gottlieb, Steen and Hamilton, where he will be returning as an associate in the fall. Next, we are joined by Anna Kolash, who is a 2L from Massachusetts. Anna graduated from Barnard College with a degree in history and worked for technology startups in the city before law school. Anna is a member of the Space Law Moot Court team and the NYU Law Review. This summer, Anna will be working as a litigation summer associate at King & Spalding. Next to argue is Rosie Coffey. She's a 2L from Atlanta, Georgia. She graduated from the University of Georgia with degrees in philosophy, entertainment, and media studies. Rosie is a member of the NYU Law Trial Advocacy Society and the NYU Annual Survey of American Law. This summer, Rosie will be working as a summer associate at Cravath, Swain & Moore. And lastly, we have Aiden Farmer, who is a 3L from Charlotte, North Carolina. Aiden graduated from North Carolina State University with degrees in history and philosophy and worked as a lab technician for an expert witness in North Carolina before law school. Last summer, Aiden was a summer associate at Kirkland & Ellis, where he will be returning as an associate in the fall. Before we begin tonight's competition, just a couple of notes for our audience members. Please, right now, make sure that all of your devices are left on silent. Please make sure that they do not ring during the competition. Please refrain from clapping until the judges have exited the room, so please do not clap after a competitor has spoken. Please also do not take photos or film the competition. We have photographers on site, and also this competition is being recorded. Thank you again to all of our distinguished panelists and competitors. We will now begin the final arguments.
Oyez, oyez, oyez. Chief Justice Higginson, Justice Forrest, and Justice Childs are now presiding. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated.
Each party will have 30 minutes total. The first half is to be spent on the issue of whether, in the absence of a designated home forum, a multi-district litigation court should apply the choice of law rules of its own forum or the forum where the plaintiff would most likely have filed. And the latter half is to be spent on the issue of whether the Due Process Clause of the Fifth Amendment requires a finding of bellwether representativeness before bellwether trial judges may be used to issue preclude a defendant in multi-district litigation. Each petitioner can reserve up to 3 minutes of their time for rebuttal. I will keep time during this argument. Advocates, you are welcome to keep time yourself, but my time will govern. Petitioners, would you like to reserve time for rebuttal?
2 minutes.
Mr. Musser, when you're ready.
May I proceed?
Yes.
Mr. Chief Justice, Your Honors, and may it please the Court, this is Micah Musser for Petitioner Paul Atreides on the choice of law issue. Mr. Atreides is suing Harkonnen Industries over his development of ulcerative colitis based on workplace exposure in the state of New Caledon. New Caledon is also where Mr. Atreides lives and has lived since 1992 when he was exposed. It's where he was diagnosed with ulcerative colitis. And yet, after he direct filed into this MDL, Harkonnen Industries insists that his failure to check a box means that Arrakis law necessarily governs his claim.
Is this a law problem or is this a contract problem? Are you asking us to give him back what he's had 2 opportunities already to do and he chose not to? In other words, he didn't check and he didn't file.
Your Honor, I would say, so this gets right away into the sort of the details of Case Management Order 53, which I think we will all agree sends some conflicting signals in different parts. And that first footnote says both that it's subject to traditional contract principles, but also that it's enforceable as a court order. I would interpret that to mean that the decisions below are subject at least to de novo review, and potentially, to the extent this is viewed as a court order, the district court should get deference here in its interpretation of its own order.
But we're going to review an issue of choice of law de novo, correct?
That is correct, Your Honor, yes.
Okay, so back to my question. Why isn't just this something he missed 2 opportunities to have validated where the court would be that he would have choice of law emanated from?
Yes, Your Honor. In response to that, I want to say I think there's generally 2 ways for the court to find for petitioner. One is on the law to say that what the district court, the Southern District of Arrakis did was a correct interpretation, that it identified an originating jurisdiction properly. But the other way to reach there, and this is responsive to your question, is to follow the example of the Seventh Circuit in Looper versus Cook and say that Harkonnen's conduct in this litigation, and in particular its role in drafting CMO 53, should amount to an estoppel of the choice of law argument it's currently trying to make.
I'm not quite sure I even understand why we're talking. I mean, I know the district court says that this is, the parties agreed to this language, and so maybe contract principles apply, but it has no effect until it becomes entered by the court. So why are we talking about contract law at all?
Your Honor, I mean, again, to our point, I think viewing this as a contract, the more we adopt that frame, the more it's actually hurtful to us, because it's, to your point, I think it's perfectly plausible. An easy way to dispatch this issue would be just to say, once this was a court order, Judge DeVries' interpretation of its effect is controlling and should be subject to only an abuse of error standard on appeal. I think that but to turn to some of the details in CMO 53, the case management order specifically indicates that direct filing will not affect any choice of law issues. Now, we might say, that may be, this CMO is almost word for word identical to one that was used in Inri Vioxx litigation in the Eastern District of Louisiana. And Judge Fallon, when he confronted this, also realized the problem that it's quite hard to promise that there's no effect on choice of law, and then you have to actually deal with the choice of law when it comes
But the
up.
goal of MDLs is essentially for you to have efficiencies. So if you allow these direct filings across the line, then you've got choice of law, everybody abiding by the same rules. But if we go with your approach, then we're undoing, perhaps reverse engineering with respect to all of these plaintiffs.
So, Your Honor, I actually think, I'm sure that my friend on the other side will hammer this efficiency and simplicity point, and I'm not sure that it cuts in their favor. In fact, let me make the argument for why it cuts in our favor. I think if you look at what the massive lower courts have been doing, many have embraced this idea that it's proper to look for an originating jurisdiction. They've identified workable rules of thumb for doing that. In prescription MDLs, the norm has become to say the jurisdiction in where a prescription was written and consumed is the originating jurisdiction. It's very odd because if you were to adopt respondents' view that Claxon necessarily controls, you would disrupt a lot of ongoing MDL cases in lower courts that have been pursuing under this understanding of an originating jurisdiction.
But the originating jurisdiction concept itself is the fiction, right? Your client chose to file in Arrakis. So the Claxon rule would say Arrakis is where the law should be determined.
So my reading, I think that collectively Claxon, Van Dusen, and Ferens, together stand for the idea that the law of the jurisdiction in which a case originated controls after, despite transfers, whatever may happen. And one way to read that is to say, in an MDL context, just the fact that you filed there is the same in principle as an ordinary plaintiff filing without an MDL ongoing. But I also think it's perfectly consistent to say MDLs are sort of a unique situation. It's not entirely clear how to apply all of the concepts in Claxon and Van Dusen onto this. We're here precisely because there is ambiguity about where we should regard this as originating from.
What rules would apply if somebody checked the box and designated a home forum, but it wasn't the proper home forum? Does the court look beyond that designation, or do we just live with the designation? What do we do?
So that would certainly create an issue that would have to be resolved on a case-by-case issue. I think probably...
But therein lies judicial discretion. Is that not the better rule?
I do think certainly that it's possible to have those issues come up and address them on a case-by-case issue. I think it's
a case-by-case for over 5,000 cases?
Well, I will point out on the top of page 8 in the record notes that Mr. Atreides is actually the first direct filed claim. Mm-hmm. I think it's completely understandable given some of the wording of CMO 53 that there's some ambiguity about what to expect from failing to check the box.
If he's the first, why did you bring up estoppel? How could the defendant here be said to be stopped from any action and conduct they've taken before?
The relevant conduct was the negotiation of CMO 53, and specifically the 14th Circuit noted, I believe this is on page 22, that respondent directly rejected a proposal to tie venue and choice of law together. They wanted to split that apart and make it ambiguous. And
well,
now they're saying...
That gets back to my question of why I asked. So is it the designation that controls? And so if one is made, then we'll just go with it, regardless of whether it was valid or not? Because the designation is supposed to be tied to proper venue. Or is it, whatever the designation is, the court still has a duty to make sure that venue is appropriate? Because we've got some sort of conflicting language in this order about what is waived when a designation is made versus what is not.
Yes, I do think that only if the box is checked and indicates a proper forum would that forum's choice of law necessarily control. But to that simple point, I mean, that illustrates that basically no matter how you cut this, there's going to have to be some level of judicial involvement and judicial checking of that box checking. So there isn't a version of this that completely streamlines everything and makes it perfectly clear. The other thing I wanted to note, though, just going back to Judge Child's question, I indicated that potentially a ruling here could disrupt a lot of what's going on in the lower courts. An oddity of this is that it might also not have much prospective value because district MDL courts could easily alter their case management orders going forward and say, you know what, Supreme Court, you said, sure, in the absence of anything to the contrary, Claxon applies, but I'm just going to put in my case management order, if you don't check a box, I'm going to identify the originating jurisdiction, and it's going to be based on where a drug was prescribed and consumed. And so that effectively...
Why wouldn't it, in this case, be where the poison began, the facility in Arrakis?
I think, Your Honor, that the Judge DeVries' position on this was perfectly a completely reasonable application of the law. He pointed to a number of facts, all of pointing to Mr. Atreides' residence and work in New Caledon. He also noted in that list of factors that Mr. Atreides alleges a violation of New Caledon tort law. And so even from the very moment that this case was filed, there was an indication that Mr. Atreides was expecting substantive New Caledon law to govern. I think that, you know, this is I certainly take some of the questions here to indicate there could be hard edge cases where it becomes ambiguous which of multiple fora a plaintiff might have intended. I don't think that this is that case. I think that it's quite clear that almost all the signs really do point in favor of New Caledon, and that Judge DeVries got that one right when he analyzed the issue.
What about forum shopping? I mean, that's a question essentially for both sides in this regard.
Yes, Your Honor. So,
because right now plaintiffs could feel that this is the appropriate forum because you had the bellwether trials and that there were some good results there, whether by settlement or by trial.
as I understand the forum shopping issues that I think respondent is likely to raise, it essentially comes down to a concern about being able to do forum shopping later in the litigation. Then no one disputes that there would have been the option to forum shop at the front end. The concern is only, is it too much autonomy to plaintiffs to be able to raise this after filing? And I would say, certainly we would accept once there's any evidence split between two potential jurisdictions on a choice of law issue, a plaintiff has to pick a side at that stage in the litigation. We don't dispute that, and that governs going forward.
But the other side of that is that when you have multi-district litigation, generally one judge has the cases, it's centralized to that judge. But in many instances, depending on which statute you're under, the judge will send the cases back. They will just do the coordinated discovery and coordinated procedural issues. So if a plaintiff has a good jurisdiction, where again, as I indicate that there were some good results here, what about the opposite, that the judge would send it back? Does the plaintiff get to claim this forum instead?
Certainly we think that if the plaintiff indicates an alternative home forum, and it is a proper venue, that should be the forum where the choice of law governs and where the claim is remanded for trial. I think that's just consistent with ordinary principles of plaintiffs being able to forum shop among those proper venue that do exist. So I'm not sure that the MDL context itself poses any sort of dangerous new expansion of plaintiff forum shopping if you were to rule for Mr. Atreides here. I think at most what it is doing is saying to plaintiffs, look, you have to make a choice, but that choice isn't, if it's unclear from the terms of the case management order and the direct filing process, the choice isn't necessarily made at the exact moment you file, but it still has to be made, and it has to be made the first moment that there's any obvious conflict between applicable substantive law.
Of course, the 14th Circuit is reversed. The district court here, you mentioned Looper, the 7th Circuit. Is there any other strong circuit authority you'd rely on, or is the Looper decision pretty comprehensive?
There's plenty of circuit authority, Your Honor. In fact,
the majority on your side.
A majority of circuits have endorsed this idea
but
that...
it's still undeveloped in the law. Before your time's up, there is quite a bit of scholarship in this area.
That's right, Your Honor.
What article, are you familiar with Professor Brandt's article?
I am, Your Honor.
And that is not favorable to your client, correct? He says the shortest distance, the issue should turn on the filer's choice.
I think Professor Brandt recognizes that the best way to have this is for these orders to make it very clear what the consequences of checking or not checking the box are. I don't think Professor Brandt, I think he's very clear that in the absence of an articulated policy in the order, there are dangers on both sides, and I wouldn't say that he's all unfavorable to our client. And with that, we would request that the Supreme Court reverse the 14th Circuit and remand the case for further proceedings. Thank you.
Thank you, Counsel. Ms. Kolash?
May I proceed?
You may proceed.
Mr. Chief Justice, Your Honors, may it please the Court. Anna Kolash on behalf of Petitioner Paul Atreides. I will be addressing the Court on the question of bellwether representativeness. Issue preclusion is a fundamental litigation tool that promotes efficiency and fairness and will help plaintiffs get their day in court without materially harming the respondent. Applying issue preclusion to duty, breach, and general causation in the current case should be permitted for two reasons. First, issue preclusion is settled doctrine that is non-dispositive and merely narrows this issue to the dispositive issues. Second, adding a requirement of representativeness is an ineffective and unworkable procedural hurdle whose purposes are already served by the structures of the issue preclusion doctrine.
But the bellwether trials exist to the extent to give a representative sample generally, so that you can then allow that to extrapolate for what the rest of the cases would be about and what are the other issues that are involved with the trial judge.
Absolutely, Your Honor. Bellwethers usually go towards representativeness in terms of settlement, so the due process concerns aren't necessarily the same here. What respondent is asking for is an addition to the Park Lane Doctrine, which is what governs offensive non-mutual issue preclusion. And Park Lane already sets out fairly stringent fairness requirements.
Step back a little for me, just in first principles. Offensive non-mutual issue preclusion.
Yes, Your Honor.
That wouldn't have existed back in 1791.
Yes,
Correct? The framers would not have even contemplated due process permitting that, yes or no?
that's correct, Your Honor. And this court abandoned the mutuality doctrine in the 70s with Blondertongue and Park Lane. So going back to the Park Lane factors, here we require that the issues be identical, actually litigated, necessary, and with a full and fair opportunity to litigate. And Park Lane gives district courts the broad discretion to apply these factors because it recognizes that when offensive non-mutual issue preclusion comes in, it's going to be in complex cases that require this discretion.
But even on the, you lost in the 14th Circuit, both under Park Lane and also added protection, correct? So the concern would be, how would this corporation have thought it needed to defend for future thousands of claimants when they were told explicitly that it wouldn't be binding, it was just informational?
Your Honor, 2 points on that. First, the decision of the 14th Circuit was grounded in the Park Lane factors. Now, it came out the other way. It's the concurrence
It
that
said
suggests...
the picture of unfairness.
Correct, and fairness is a Park Lane analysis. But to the informational function of bellwether trials, first of all, Your Honor, that's not necessarily mutually exclusive with issue preclusive effect. Bellwether trials are dispositive in the sense that they almost always lead to settlement.
But you need a larger sample. How many? You only had 2, correct? Full to trial?
Yes, Your Honor, that's correct.
Okay, so how, I mean, you've probably seen the opinion, someone says statistics 101. How do we extrapolate 2 to get preclusively thousands?
Your Honor, that's exactly the point, is if we require representativeness, we have to get there statistically, which, as the court correctly points out, is probably impossible for a district court to do without statistical experts. Here, we're talking about very broad issues. I would refer Your Honors to the jury instructions on page 31 for reference. If we have a jar of marbles and all the marbles are the same color, it takes 1 marble pulled out to know what color that is. It's different if the colors are different, but here, where
So
we have...
your position, if Harkonnen had won even 1, we'd have the, what is it, Professor Curry problem, the railroad situation? Had they won 1, you wouldn't be able to say there was representative? Is there some magic number?
My argument, Your Honor, is that if the petitioners won 1, that would have been enough to be representative for the purposes of issue preclusion. The Professor Curie problem is more relevant for the class action context. Here in the MDL, the respondent has the opportunity to litigate 10,000 cases on their merits to specific causation if it so chooses. That is not for nothing, and specific causation is no walk in the park. Petitioner will also have to prove damages and any other additional claims he wishes to bring.
But in many MDL cases, you'll allow the judge to have the representative trials on duty, breach, and causation. And then even specific causation and damages could just go over, sometimes even to a special master in that regard. So what are you actually challenging with respect to the issue preclusion?
Your Honor, our position here is that issue preclusion should be permitted for duty, breach, and general causation, which are the general issues. Now, if I'm correctly understanding your question, and there's concern that these issues will sneak in future cases to issue preclusion,
Yes.
we have these Park Lane factors for a reason. They're stringent. Starting on page 10 for almost 5 pages, the district court goes through them one by one. And this is an abuse of discretion standard. It's very hard to say the district court abused its discretion here. And if that fails, we have interlocutory appeal. Your Honors, we accept that our justice system is not perfect.
But you do accept the molten core of due process is notice. You accept that proposition.
Absolutely,
And
Your Honor.
Harkington was told, these are not binding bellwethers. No one agreed that these would be binding. So,
Absolutely, Your Honor.
And you would expect that they wouldn't have put up all of their defenses.
Let me take those in turn. First,
Yeah.
on the binding issue, these are not binding, they're issue preclusive. Chevron from the Fifth Circuit considered binding cases where the preclusive effect is determined ahead of time. Here, this is determined by the second forum, applying the Park Lane factors looking back. Your Honor, if you could repeat the second question?
I have to think through it.
I'm sorry, my apologies.
The Supreme Court, we cite just a few scholars regularly. One of them is Professor Zakharov at NYU. Do you know what he would say as to whether MDLs give defendants sufficient due process? Just from 2 or 3 bellwether?
Your Honor, I think
Has he written on this issue?
I think that Professor Zakharov would agree with Judge Childs' earlier point that the purpose of MDL is efficiency. And the fairness concerns, the due process concerns.
He said, we know from lexicon, efficiency can't trump, ultimately.
Of course not, Your Honor. And that's the Park Lane analysis comes in and protects the defendant's fairness concerns here. I think that Professor...
Well, and back to fairness concerns, I recall the question. The question was that having a defendant also on notice allows us to have the defendant put forward their defenses at that time based on the issues before the court.
Thank you, Your Honor. On the point of notice, issue preclusion is a fundamental litigation principle in our system. It would be sort of fantastical to say that defendants, especially one with the resources of Harkonnen, don't know about issue preclusion and aren't on notice that it could happen.
Well, to follow up on that point, I'm looking at the jury instruction for duty, and it asks the jury to find whether a reasonably prudent corporation would have foreseen that injury was likely to result to someone in plaintiff's position. So what about, that's an individualized question that the jury was being asked in these bellwether trials. And what about that process of answering an individualized question is going to give anybody notice that their answer to that question is going to have any sort of effect beyond that particular case?
Well, Your Honor, I wouldn't necessarily agree that the language in the plaintiff's position is individualized. Here, if we think about the harm, Harkonnen poisoned the groundwater. It's reasonable to think that anyone who drinks the groundwater is going to be harmed. It's foreseeable that anyone...
But isn't there evidence in this record that that harm can change depending on where you are relative to where the point source was, where the pollution actually emanated from, and the amount of time that has passed, and all these different factors?
Including the type of medical injury that you would ultimately have.
Absolutely, Your Honor, and all of these will be litigated at specific causation. The Sixth Circuit actually recently addressed this question right on the head.
Well, this instruction that I'm reading is about the duty. So, that's a totally different element. And so the question is, do you have a duty to someone? And that depends on whether you can reasonably foresee a harm to them. And if the circumstances of how they encounter the pollution, where they are, how long it's been, all those sort of things can impact that, then how can a decision on the individualized decisions of these bellwether trials have an effect beyond those particular cases?
Yes, Your Honor. On the point of foreseeability, I would go back to the jury instructions where it says the test for foreseeability is whether a reasonably prudent corporation would have anticipated that the action would have caused harm. Foreseeability is not individualized. And in fact, we had an expert witness at trial, this is page 11 of the record, testify to that it was foreseeable that people beyond just the water district would come in contact and be harmed. Going back to the Sixth Circuit case, in re E.I. DuPont, they settled the same way. It was a water pollution MDL case considering the exact same issue and found that location did not impact foreseeability. Now, this may impact specific causation, which respondent will absolutely be able to litigate. I'd like to move to
Before you move,
Yes, Your
two
Honor.
questions about the record. One is, these bellwether trials were chosen by the parties. There was no instruction that they be representative. In fact, they were the opposite, right? In other words, the parties were told, pick your best case. So how would they possibly correlate to your client years later in an entirely far downstream?
Your Honor, this goes to what makes a case strong. I would absolutely concur that both sides are going to choose their strongest cases. And with an eye on settlement, the strongest cases are going to be the cases where the disease is the most harmful, the exposure was the highest. These go to specific causation and damages. They don't go to the jury instructions that we just recited.
Right, but doesn't that make them non-representative? They're outliers. And if the goal is to preclude future cases like your client,
Yes.
wouldn't we need typicality?
Yes, Your Honor, and that is covered by the Park Lane factors, which requires identicality of issues. Here, the issues are identical in terms of duty, breach, and general causation. They're certainly not identical on specific causation.
But you also could take it the other way where you would think that a typical case in the defendant's mind would be something that's a weaker case, and you just want to test out the jury to see, do they give a lot of money even with the weaker case just because you drank the water?
Absolutely, and respondent had the opportunity to choose 3 of those bellwethers. They chose to settle 4 of them. We don't know which ones were settled. But in terms of fairness, both sides chose an even amount. If these are representing outliers, that's true. But as I mentioned before, the outlier status doesn't impact the general issues because those facts don't go to the general issues.
And Park Lane had fewer plaintiffs, but we're talking about mass tort MDLs. Why not go with the Matthews case?
That's correct, Your Honor. The Matthews-Doer test, first of all, has never been applied by this court in the context of aggregate litigation. Its application in this context comes from Halal on the Ninth Circuit, which was a class action case, and I would note has been severely criticized by other circuits and not adopted. Even if we apply the Matthews-Doer test, the Matthews-Doer test balances the interests of the party, the interests of the judiciary, and the risk of error and added cost in the procedure. Here, potentially it's certainly in the respondent's interest to litigate these trials on every issue. It is definitely in the judiciary's interest to have an efficient trial. Your Honor, at this rate of litigation, this trial is going to outlive everybody in the room.
Well, let's talk about that, though. Should we be more concerned about the procedural rules that go around MDLs? And again, going back to my first question about efficiency, how does that factor in terms of any limiting principle when we're also needing to be concerned about substantive rights?
Your Honor, the MDL statute is created by Congress, and Park Lane adds onto that balancing factors between efficiency and fairness. At the end of the day, fairness always trumps. But this is not an unfair outcome for respondent. They've had 30 years to litigate this case, and they've conceded to poisoning the groundwater. They were also the ones who motioned for this MDL twice. What we're asking for is simply a preservation of the issue preclusion doctrine that is working in practice. What respondent is going to ask you to do is to overhaul a doctrine to fix problems that exist for them. For the foregoing reasons, I would request this court reverse the decision of the 14th Circuit. Thank you.
Thank you, counsel. Ms. Coffey? You may proceed.
Good evening, Your Honors, Mr. Chief Justice, and may it please the court. My name is Rosie Coffey, and I'm here today on behalf of the respondent, Harkonnen Industries. I'd like to ground my argument today in the procedure that we're asking this court to adopt. Step 1, check the short form complaint for an alternative home forum designated by the plaintiff. If such a designation has been made, give that designation deference to the extent that it is compatible with traditional venue and jurisdiction principles. If no designation has been made, apply a Claxon presumption to the plaintiff's claim and the law of the state where the MDL court sits.
In many other contexts, for example, in discrimination law, we don't allow people to just waive their rights when there are substantive rights at issue. So why should we do that here?
Your Honor, we don't consider this to be a waiver of rights because nothing about this Claxon presumption impacts plaintiff's ability to forego filing pursuant to the direct filing order. Nothing this court holds today will prevent plaintiffs from filing in the state of their choosing and then using the JPML to effectuate transfer to the MDL court and then comfortably applying the letter of Van Dusen to their claims. In fact, direct filing orders like CMO 53 in this case, we don't read as Claxon mandates, as constraining plaintiffs to the law of Claxon simply by virtue of direct filing into an MDL. We read them as giving plaintiffs the option. On that direct filing order on page 33 of the record, Mr. Atreides had the option to designate where he would have filed absent this direct filing order.
We didn't take cert just to sort of make a contract interpretation. So, I mean, your position so far, I understand, is he slept on his rights. But when we look at 1407, the statute we're trying to construe, there's nothing in there that says Congress told us that the Van Dusen rule doesn't apply. Is that correct?
Yes, Your Honor, that's correct.
And in any way of looking at the Arrakis court, it is a receiving court.
Yes, Your Honor, it's a receiving court in that it is the court that is receiving these MDLs in any way that they're filed, either with this filing order or through the standard application of Van Dusen from other districts. Now, I'll move on from the contract interpretation of this case after making the point that it is undisputed that Mr. Atreides had the opportunity to designate a home forum, and he chose not to make that
The
designation.
plaintiff has no meaningful connection to the forum, did not sign the form, and then was directed to direct file. Why shouldn't that be given some consideration as well?
Yes, Your Honor, we disagree that plaintiff has no meaningful connection to the forum. Unlike in other multi-district litigations, Arrakis is not some disinterested third state. It's the place where all of Harkonnen's alleged negligent conduct occurred. This is sufficient to incentivize plaintiffs, including plaintiffs like Mr. Atreides, to file suit in Arrakis even if they don't live there, don't work there, and weren't necessarily injured there. This is the right that plaintiffs have, plaintiff's venue privilege, and it's been affirmed by this court time and time again, including in Van Dusen and including in Ferens v. John Deere. Now, you may believe that Mr. Atreides would have filed suit in New Caledon absent this direct filing order, but 10,000 other plaintiffs have used this direct filing order since, and presumably some of those 10,000 other plaintiffs left that forum designation slot blank.
But we know whether he filed there or not, at least scholars have pointed this out, we know that's the remand court. Why doesn't that give us certainty as to what court's law should apply? In other words, it was sort of an accident of bureaucratic convenience. He wanted to skip 2, 3 different clerk's offices. The system encouraged him to, but we actually do know that the remand court is New Caledon's. So why doesn't that tell us where it's not a fiction, it's actually, that's the originating court?
Actually, Your Honor, if you take a look at the language on CMO 53, it indicates that absent an alternative home forum designation, the default home forum will be Arrakis. That's where the case will be remanded for trial.
Yes, but the language also is pretty clear that it's not deciding choice of law.
Your Honor, we disagree. At the very least, what this contract does is it puts plaintiffs on notice that the strength of their choice of law argument will be impacted by their designation of a home forum. You can see that in the last paragraph at the bottom of the page there, which reads, "Nothing in this order shall preclude or restrict the right of any party to argue for a specific state's choice of law rules based on the appropriate home forum designation."
What happens to your argument if we fully reject the contract theory?
Your Honor, even absent this contract theory, petitioner advances no alternative reason why Arrakis state law should not apply to his claims.
Do we not give any deference to the judge who wrote the order and entered it? I mean, I recognize that the parties proposed the language, but he entered it. It's his order.
Yes, Your Honor. With respect to the deference surrounding this contract principle, even if we put this contract aside, there are reasons to still find that a Claxon presumption outweighs the judge's order in that first case.
Okay, so yeah, list those reasons, put the contract aside, because it seems like most veteran MDL judges, almost against efficiency, are looking to the law back at the originating state.
First, yes, Your Honor. But what those judges are doing in the majority of these circuits is they're looking to plaintiff's designation of an alternative home forum. That's how they're getting the definition of an originating state. It's true in the Bear Hugger litigation out of the 8th Circuit.
So but this is back to he's slept on his rights in this particular case. What about my question about we know the originating district because we know and have to discern where the remand court would be? Let me turn that into a question about scholarship. Have you looked at Professor the article Meta Split?
Yes, Your Honor.
And what's the name of that professor? Renzenberger?
Renzenberger, I believe.
Okay. Isn't that what he says the focus should be? We should identify choice of law with the court that will receive the case on remand.
Yes, Your Honor. We believe that the court that will receive this case on remand pursuant to this direct filing order is Arrakis. And we completely agree that the forum who receives this case on remand and the choice of law principles that apply during pretrial are a closely
So some
related
poisoned
issue.
residents in New Caledon will get Arrakis law and other New Caledon residents similarly poisoned will not? You're comfortable with that dissimilarity?
Yes, Your Honor, because plaintiffs have the right to file suit in either of those places and retain the benefits of the law that flows from both of those states. In this case, both Arrakis and New Caledon are proper venues for Mr. Atreides' claim.
Well, I think this comes back to this sort of theme that has been is this about contract rights and individual choice, or is this about how the law should work and sort of a fairness view systemically? And you want to emphasize choice, and you could have done something different to have different law apply if you really cared. But why should we give so much deference to people's choice in this context when the whole MDL system was about efficiency and sort of streamlining preliminary matters, and not the whole ball of wax in terms of trying all these cases through this one process?
Yes, Your Honor. Moving on from the contract in this case, I think we can all agree that what we're looking for from the court today is an ex ante answer for how we define the choice of law principles that apply to plaintiffs who fail to make this designation clear. That way, we can give plaintiffs notice on what to expect when they decide how to file into an MDL. Petitioner proposes an originating state theory, and he's correct to note that lower courts have decided cases on these grounds. But he failed.
Is that not just lower courts, having all circuits except for the 14th?
Yes, Your Honor, that's correct.
And the 14th, that we're reviewing, didn't acknowledge a single one of the other circuits, did it?
That's right, Your Honor.
And isn't that the only way to ensure that like parties are treated like?
Your Honor.
I mean, this gets to Justice Higginson's question about you're going to have people from Caledon that are treated differently depending on how the form looks. Does that make sense?
Yes, Your Honor, we believe it does make sense in this case because some of those plaintiffs made that choice willingly. You can think of reasons why plaintiffs, even those who might have...
So that comes back to we're just going to let the plaintiffs who fill out the form sort of govern how this should go.
Yes, Your Honor. It's our position that designations by plaintiffs should be given deference unless the court finds that they don't comport with venue and jurisdictional
Does the record
requirements.
reflect that Mr. Espadis has had counsel throughout the process?
No, Your Honor. The record doesn't tell us much about Mr. Atreides.
So if they're a pro se litigant pursuing a case and missed the checkbox, it seems less compelling.
Your Honor, even assuming that Mr. Atreides is a pro se litigant...
Or was. He has NYU counsel now. But...
That's right, Your Honor. Apologies. What we do know about Mr. Atreides is that he was at least minimally informed about the content of this litigation. And we know that because the record at 8 tells us that he pled the exact same claims as the plaintiffs that came before him, including the same core factual allegations, that's at 11, and the same core facts from the bellwether trials, that's at 12. So at minimum, Your Honors, that tells us that Mr. Atreides was informed enough about the subject of his claims to read this direct filing order, but at most, it tells us that Mr. Atreides wanted his claims to look like the plaintiffs that came before him and won a lot of money from Harkonnen in those bellwether trials.
And what do we do about the plaintiff's concerns with respect to the defendant's forum shopping and that them having affiliations with the JPML panel and that them wanting to be in this forum themselves and choosing the forums?
Yes, Your Honor. The JPML acts as a stopgap for any defendant forum shopping here. And while it may take recommendations from parties on where that forum should be, we believe that the JPML issues that final designation onto where to centralize cases for an MDL.
Two legal questions. Do you draw any support from Rule 16.1 or the commentary? Because when I read the commentary, it seems to be warning you that you should set up the ground rules very clearly before that CMO was finalized. And the second question is, if you had to say in one sentence what the flaw in the reasoning of the Seventh Circuit's Looper decision, what would you say the flaw is?
Yes, Your Honor. First, to your Rule 16.1 question, that's exactly what we're trying to do today, is set up a groundwork that goes into effect before direct filing orders take place. To your second point, on the Looper decision, the flaw in the Looper decision is that it's in opposite to this case. The Seventh Circuit decided Looper on the grounds that the defendant had impliedly consented to the choice of law principles advocated by the plaintiff. That is not the situation that we're in today. In fact, nowhere in this case management order is New Caledon mentioned one time.
Do you agree with opposing counsel that this is the first direct filed case? In other words, there was no earlier line of conduct behavior.
Your Honor, the record reflects that Mr. Atreides is the first plaintiff whose direct filed case is proceeding to trial, not necessarily that he was first in line of those direct filing plaintiffs. Now, moving on to why this originating test presumption is far less efficient and far less administrable than the Claxon presumption, is the issue that lower courts can't seem to decide how to define what the originating state is. Petitioner proposes a prescription and consumption test that conveniently disregards the fact that the place where a drug is prescribed and the place where a drug is consumed are often two different states. In Sanchez v. Boston Scientific, the Southern District of West Virginia held the originating state to be the place of implantation. And then in the Yasmin litigation out of the Northern District of Illinois, that court held that place to be the place where the drugs were purchased and prescribed. Today, petitioner benefits from a fairly straightforward record. All of the conduct that he alleges to put him in contact with Harkonnen happened in one state, New Caledon. But you can easily imagine a plaintiff who, say, filled up a water bottle in the Arrakis River at work in New Caledon, took that water home and drank it in Arrakis. And so then, by analogy to a place of implantation, it looks like Arrakis should be the originating state. But if we're looking at where he first came into contact with that water, that looks like New Caledon. So how do plaintiffs know what they're getting from an originating state that isn't tied down to one definition? And more importantly, is this kind of fact-intensive inquiry the kind of thing that we want MDL courts to do when, like in this case, they're facing 10,000 direct filing plaintiffs? Our proposition today, Your Honors, is that we reverse this order of operations. Apply a Claxon presumption unless plaintiffs designate that they would have filed elsewhere, and unless some sort of venue or jurisdictional problem arises through that Claxon presumption. Through that, we believe that the twin aims of multi-district litigation, efficiently resolving large cases and resolving the individual cases that make them up fairly, are best met because, importantly, Your Honors, this presumption is easily and individually rebuttable in every single direct filed case. If there are no more questions.
Well, I'll just ask a general one. Give me just sort of basics on what mutuality and non-mutuality mean here. You're acknowledging that there is no mutuality here?
Your Honor, mutuality in terms of the plaintiffs
Yes.
in these cases?
Well, the parties' alignment here.
The parties' alignment here. We believe that the claims that plaintiffs are alleging and the responses from these parties are mutually aligned in that there's no disagreement that this MDL should proceed in the MDL. There's no argument that this case has properly been consolidated here. The disagreement is on which state's choice of law principles should govern
Right,
retrial.
and I was just curious about how different the two choice of law principles are.
I see, Your Honor. May I
Yes,
briefly
yes.
answer? So it's stipulated to in the record that whether the decision on which state's choice of law principles should apply will resolve.
Determinative.
Yes. If Arrakis choice of law principles apply, the parties agree that Arrakis law will control, and vice versa for New Caledon.
Okay. Thank you, counsel.
Thank you for your time.
Let's see, I might have lost track. I think it's Mr. Farmer, is that correct?
May I proceed?
Yes.
Thank you, Mr. Chief Justice, and may it please the Court. Your Honors, two cherry-picked bellwether trials should not be allowed to determine the outcomes of critical negligence issues across 10,000 cases.
But you were part of the cherry picking.
Yes, Your Honor, we were, but we were not on notice that issue preclusive effect would apply to these cases.
But you were on notice that a lot of meaning was going to be taken off of these first test cases in terms of how things were going to go going forward. I mean, it's not like they were just run-of-the-mill cases. Everybody knew a lot of attention was going to be put on them.
Yes, Your Honor. We knew that we were going to use the outcomes of these cases for settlement. But the calculus for how we approach those cases when we're using them for informational purposes is very different from how you approach a case when you know that critical issues will turn on it in 10,000 cases.
Well, I mean, I understand that you're going to make an argument about due process, but let's just say that we're going to go under the traditional analysis. And we look at the motivation or the incentive that you had to litigate these issues below in these earlier trials. And I'm having a hard time understanding why you wouldn't have had every incentive to litigate them as hard as possible because you knew that they were going to be used for settlement information. I mean, that's a significant reason to litigate them strongly. So why isn't that meeting this fairness concern?
Your Honor, it isn't meeting that fairness concern because we did not take this into account when we chose the cases. Each of these cases was chosen unilaterally by the parties, and we did not necessarily know that we were going to be testing the entire waters of every kind of claim that could be brought. We can look at Mr. Atreides' case and see that he has many critical factual differences from the bellwether plaintiffs. We were not concerned about these 10 years ago, but when 10,000 new claims have been filed, we are concerned that there might be new issues which we did not take into account.
Just as a factual matter, are these new, I think they're called tag-along claims, are those plaintiffs part of the class?
No, Your Honor. They've been brought as part of a new wave of claims in 2023. They were not party to the original class action tolling agreement. The district court is applying preclusion on the first of this new round of claims to go to trial.
So what effect did the stipulations and the other sort of concessions that happened in the class have on these tag-along cases?
Your Honor, our client has conceded that PFAS can cause ulcerative colitis in accordance with the tolling agreement. We do not seek to challenge that at this time. But we would challenge whether we owed a duty to Mr. Atreides. To turn your attention to the jury instructions on page 31.
Well, before we do that, you do have two parts to your argument. One is just under Park Lane and the factors. The second is saying we should constitutionalize a little bit more. Which is your primary argument?
Your Honor, our primary argument is under Park Lane. The due process argument comes from the fact that issue preclusion is subject to due process
So on
limitations.
Park Lane, just going down their factors, there's no issue of wait and see by these plaintiffs, is there?
No, Your Honor, there is not.
So one for them. Number two, you did have a full and fair opportunity. In other words, you had every incentive to try to win, and you universally lost. Those are sort of mixed factors under Park Lane.
We lost in the two bellwethers that we took to trial, Your Honor.
Right.
But we have new defenses in this case that we did not have the opportunity to present in those bellwether
But that
trials.
was part of the grand bargain. You got, what, 7 or 10 years stasis, no litigation, and you've carved out a ton of illnesses. This was all what you obtained. But now you're trying to undo the small portion that they obtained, which is that you're stuck with this causation ruling. And you're stuck with the negligence ruling that you've lost each time.
No, Your Honor. We are stuck with the general causation ruling, and we do not contest that. But we were under no notice, nor did we agree that issue preclusion would be applied to
How
results
many
of these.
bellwether trial losses would be enough to have given you representativeness?
Your Honor, we don't say that there's a critical number, but what we do say is that some forethought must be put into how the cases are selected, not necessarily how many.
So what's the metric that you would have selected on different than you did select on if you had known that preclusion was on the table?
There are a few issues. One is the water district in which the plaintiff resided. All of the plaintiffs from the bellwether trials resided very close to the plant in Arrakis. Mr. Atreides lived at the southern end of New Caledan in a district that it had less than the EPA recommended maximum for PFAS exposure. We would also do it by time because those regulatory guidances changed over the course of the 90s.
Can't you still bring up those issues in terms of specific causation, which is an open question?
Not with respect to the regulatory guidance, Your Honor. The regulatory guidance in 1991, when Mr. Atreides alleges exposure, was 0.25 parts per billion of PFAS. By the time that the bellwether plaintiffs were exposed, the regulatory guidance had changed to 0.1 parts per billion. Mr. Atreides was exposed to less than either of those amounts. And this goes to whether it was foreseeable that PFAS exposure would cause harm to someone in Mr. Atreides' position, which is how the jury instructions that Your Honor was reading earlier phrased the question of duty.
But you at least knew that there were 3 types of medical diseases or injuries, and Mr. Atreides does come within those definitions, correct?
Yes, Your Honor. He suffers ulcerative colitis, and one of the bellwether trials was of a plaintiff that suffered ulcerative colitis.
And so back to going on notice, what else did you need to know to be on notice with respect to duty, breach, and causation? What would you have done differently in defending?
We would have brought different cases where plaintiffs were exposed to lesser amounts of PFAS and in different water districts. Now, I'd also like to turn your attention to...
Wait a minute, I may have misheard you, but I thought you were talking about those points have sort of time has passed and more is known. So if those issues are based on things that you now know that you didn't know back then, how would they have impacted your choices then?
So, Your Honor, I'd like to clarify. Those changes occurred in the 1990s, long before the Bellwether trials. It's
Okay,
a difference
I
of
misunderstood you.
it's
But
a
you're not
difference of
challenging the science.
No, Your Honor. We're challenging what we knew at the time that each plaintiff was exposed. What happened to these plaintiffs is tragic, but we did not know that PFAS could cause injury in these levels when Mr. Atreides was exposed. He was exposed for a 15-month period to less than the EPA recommended limit for PFAS in drinking water, and he was exposed purely from occupational exposure. We believe that a jury might come out differently on the issues of duty and breach with respect to this new information, and we have a due process right to present those arguments. I'd also like to specify that we're not asking that you take issue preclusion off the tables in MDLs forever. All we are asking is that forethought be put into how these cases are selected at the outset, not 10 years later when 10,000 new claims are discovered.
What's the relief you're requesting? Could we remand just to have inquiry into how representative these two were?
Yes, Your Honor, you could. But we believe that that inquiry would necessarily lead to the conclusion that they were not representative. There is no magic number, but we can see the court in re Chevron concluded that 30 Bellwether trials was not enough to determine an entire negligence
But I'm
claim.
still not understanding, what do you perceive as being representative? Because you're talking about some plaintiffs that could have had less interaction with the water, and then these trials were those who had more interaction with the water. So what's representative?
Your Honor, we would propose a batching approach to address that issue, where you create groups of plaintiffs based off specific factual variations, namely what water district they were exposed in and what the PFAS levels were at the time they were exposed.
With the ruling that's going on now, could you not carve out, I mean, most of these multi-district litigations absorb a fact sheet right from the beginning, and those kind of facts could have been on that particular fact sheet. So could you not carve out the similarities for those who match the rulings that the court has already done with respect to the causation element?
It's possible, Your Honor. What we would say is that this is the kind of analysis that should be done at the beginning.
Has any court done the analysis you're recommending that we impose?
Yes, Your Honor. It's already required in the 23B2 class action certification inquiry.
Right, but I'm in the MDL context.
Yes, Your Honor. The Fifth Circuit requires that this be done before bellwethers be given binding effect since the late 90s.
That's the Chevron decision.
That is the Chevron decision, Your Honor.
And was there sort of a backup in the Deepwater Horizon cases that you're stuck with the bargain you made?
Yes, there was with respect to the plaintiffs who were party to the original tolling agreement. Those plaintiffs' claims have been settled. We performed our bargain to those plaintiffs. What we're dealing with now is 10,000 new claims that have been discovered on the wake of additional press coverage of the facility.
Well, help me out with why you want the plaintiffs to be forced into this choice of law portion of the case with respect to leaving everything in Arrakis, but then you all want to have a different procedure with respect to the duty, breach, and causation in terms of what law applies to you.
Yes, Your Honor, because we think that this issue is going to be paramount in MDLs going forward. My opposing counsel referenced the Abbott decision, which came down very recently. In that case, the Sixth Circuit seems to open up the door to these kinds of broad applications to preclusion on specific elements. Now, that case was a significantly less troublesome factual scenario. It was being applied to the final plaintiff in a closed class of plaintiffs party to a tolling agreement, whereas this case kind of represents the worst case for how Abbott could be applied. It's being applied to the first claimant of a brand new set of 10,000 claims, 10 years after the bulk of them were settled. Now, if this court allows the district court's ruling to stand in this case, what rational defendant would consent to enter into bellwether trials under those stakes? The stakes are simply too high to sacrifice the entirety of 2 whole negligence issues across 10,000 cases.
What were you trying to gain then from these particular bellwether trials that were selected?
We were trying to inform the settlement agreement that we came to in 2013. We were able to productively resolve 5,000 claims with the results of those
But that sounds
bellwether
like you were
trials.
just trying to get to a number, like what were the cases worth? What about the legal issues that should preclude other cases?
Yes, Your Honor. We were interested primarily in the numbers, and those numbers we saw a lot of variability and we saw a lot of uncertainty. Punitive damage awards vary by up to $10 million just in those 3 trials.
But the whole purpose of an MDL is that you would have this efficiency, this similarity of rulings, that there wouldn't be inconsistent rulings if these cases were tried in 26 states by 30 different judges. So again, what were you trying to gain other than the numbers? There has to be something that's more efficient about the MDL process.
Yes, Your Honor. We were trying to get a broader sense of how many plaintiffs were out there, what our total liability would be, and how much each plaintiff would get. We were primarily concerned with the numbers. But the efficiency comes from the fact that we had a centralized forum to enter into negotiations with all 5,000 of these plaintiffs at once.
But when you go to MDL, just to keep pushing the point, that judge is trying to avoid inconsistent rulings. So you're going to be trapped with some of those rulings for all of the cases. You go into that knowing that that's the case. That's the purpose of an MDL.
Yes, Your Honor, but we don't think that that can be applied to jury verdicts. It can be
Well,
and is.
one wonders if that would still be true if the bellwether trials had gone in your favor.
Your Honor, if the bellwether trials had gone in our favor, we would not be able to apply issue preclusion to these plaintiffs. Issue preclusion requires that we apply it only to a party that was a party to the original judgment. We cannot preclude Mr. Atreides with the results. And that fundamental asymmetry is part of why issue preclusion becomes fair in the aggregate litigation
Just
context.
before your time's up, because you're pretty much still arguing simply in the orbit of Parkland, but you had a more ambitious constitutional argument. Have you abandoned that, or do you want to press that? And if you do want to press it, is it based on the Fifth Amendment, or does it draw from the Seventh Amendment as well?
Your Honor, I'd like to specify what the due process clause and specifically Matthews v. Eldridge is doing in this case. It was raised by the concurrence, and my opposing counsel is correct that this has not been applied to this specific legal issue. We already know that issue preclusion is subject to due process limitations from the Taylor v. Sturgill case. And all the Matthews v. Eldridge test is doing in this case is giving us a helpful gloss on what it means to have a full and fair opportunity to litigate under Parkland.
And we would look to Rule 23. Where would we look to this new mini trial on representativeness?
Yes, Your Honor, we could look to Rule 23, we could look to binding bellwethers, but we can also simply reason from first principles from the Matthews test. In this case, plaintiffs are not harmed by the imposition of a representativeness finding. All we are asking is for a different means of selecting the bellwether trials at the outset that will comport with due process. Plaintiffs can then apply issue preclusion to those results. This, by contrast, the harm to defendants is rather great. We are being constitutionally precluded from raising valid defenses about the regulatory guidance as it pertains to duty across 10,000 cases, and that will meaningfully increase defendants' risk of liability.
You've heard me asking other counsel about scholarship. Is there any scholarship that endorses this constitutional extra?
Yes, Your Honor. There is scholarship that endorses the removal of any kind of binding application of the bellwether results to subsequent trials. There's also scholarship that distinguishes between the types of trials in Chevron and the types of trials here with issue preclusion, but we are familiar with no scholarship that would support applying issue preclusive effect based on 2 bellwether trials chosen by the parties 10 years prior under the express guarantee that those trial results would be non-binding.
So I have one last question. I'm left here still a little bit puzzled in terms of this is the Supreme Court. We're not just deciding this case. We're trying to sort the law. So how is it that you would have us write this rule in terms of what's the plus that has to be established to satisfy the standard?
Yes, Your Honor. I realize we're low on time, so I'll give this to you very simply. I request that you create a rule that due process requires a finding of bellwether representativeness before issue preclusive effect is granted to bellwether trials and MDLs. Thank you.
Thank you, counsel. Some reserved rebuttal time. Will you be splitting rebuttal time, or will you be arguing?
2 minutes each.
2 minutes each, okay.
May I proceed?
Yes.
2 points, Your Honors, and I'm going to call these following some of Judge Forrest's questions, a contract point and an efficiency fairness point, so I make sure we generalize a bit. On CMO 53, my friend on the other side got up here and in response to some of the Chief Justice's questions said, well, paragraph 3 of CMO 53 makes Southern District of Arrakis the default forum, so that should settle this. Choice of law and forum should go together. But then in paragraph 4, it says that even if a plaintiff does check a box, based on the appropriate home forum designation, Harkonnen can still argue for the application of a different, more favorable choice of law. Since Arrakis law is the more favorable law, this is essentially a heads I win, tails you lose interpretation of CMO 53. I don't think that this court should endorse that view.
Is there an obvious remand court here?
I'm sorry, could you just...
Is there an obvious court that the case would be remanded to after the preliminaries were resolved, assuming no settlement?
I think the point I'm just making there is this case management order already splits apart venue and choice of law.
Yes.
I do think, yes, Southern District of Arrakis is the presumptive forum for remand unless the parties stipulate otherwise.
It's just that problematic clause at the end, right? That I think the language in that last fourth paragraph, based on the appropriate home forum designation. And what are we supposed to take from the meaning of that?
It's not the most artfully drafted document, and that's why I would say my more general point on efficiency and fairness. MDL courts have been doing this. They've been doing it consistently. None of them have registered discomfort with the inefficiency of identifying an originating jurisdiction, and accepting my friend's position would potentially upset an untold number of pending cases that had already had choice of law established based on this identification of an originating forum, and might have very little effect going forward if district courts just redraft their CMOs. For the foregoing reasons, I would urge this court again to reverse the 14th Circuit and remand for further proceedings. Thank you.
Thank you, counsel.
Your Honors, respondent seeks to turn the MDL into a class action, and as a result, we get all the problems of a class action. 2 points here. First, respondent suggests that we break plaintiffs into subclasses. Here we run into the familiar problem from the class action setting of subclasses all the way down. Disease type, level of exposure, geography of exposure, you can keep going in granular variables until you have 100 subclasses. Congress tells us that the purpose of the MDL is to produce just and efficient conduct. This will add enormous pretrial litigation, as Your Honor correctly labeled a mini-trial before we can even get to the bellwether plaintiffs.
What about their point that in Chevron, the Fifth Circuit said even 30 bellwethers wasn't enough?
Your Honor, that goes exactly to the point of efficiency here. We have 30 bellwethers. 3 bellwethers took 10 years and numerous litigation and motions and interlocutory appeals. Representativeness is also coming from the class action context, and this is because class actions consolidate cases for a final decision. MDLs do not do that. They consolidate cases for pretrial purposes only. In the class action context, there's a greater due process demand because class actions bind potentially absent plaintiffs who have not had their day in court. The concern here is not the same because we are precluding a party who has had 30 years in court. Representativeness is not a factor this court needs to add to the Parkland analysis. Thank you.
Thank you, counsel. The case is submitted. Thank you very much.
All rise. The court is now in recess. Justices will now deliberate in their chambers. Please follow me.
you can all be seated. You can keep clapping if you want, but you can go ahead and sit down. Good evening, everyone. My name is Emily Payne. I am the 2025-2026 Moot Court Board Editor-in-Chief. While the judges are deliberating, we're going to go ahead and begin the award ceremony for all the other awards that have been given out over the course of the past year, except for the one award that the judges will give out this evening, which is the Orison S. Marden Award for the Best Oral Advocate. The awards that I'm going to announce right now recognize winners from the many rounds completed in both the fall and the spring. All of the competitors of this year's Marden competition, and especially these award winners, have taken hours and hours out of their very busy law school schedules to spend time researching, writing briefs, preparing, and delivering their oral arguments over the course of many rounds of the fall and the spring Marden competition. And over the course of both semesters, we've heard from practitioners on how incredibly skilled and knowledgeable our competitors are, including the 4 competitors here and all of the competitors from the fall Marden rounds. So we are incredibly impressed with all of them and hope that all of them are very proud of themselves. If the winner is present for the following awards, please come up and collect your certificate from Alicia and Sung. I believe photos may be taken. If they are not present, you can still clap if you would like. For the best overall performance by a member of the Moot Court Board in the 2025 Fall Preliminary Round of Marden, the Best Moot Court Competitor Award goes to Anne-Marie Artie. I believe she is not here. Yeah. For the best brief by a member of the Moot Court Board in the 2025 Fall Preliminary Round of Marden, the Moot Court Board Brief Writing Award goes to Ben Salinger. Do you guys want to go over there so you can be in the front? Yeah. Okay. For the highest oral advocacy score achieved by a member of the Moot Court Board in the 2025 Fall Preliminary Round of Marden, the Moot Court Oral Advocacy Award goes to Aramis Boileau. For the Best Oral Advocate in the 2025 Fall Preliminary Round of Marden, the Marden Oral Advocacy Award goes to Sean Welch. For the best brief written in the 2025 Fall Preliminary Round of Marden, the Marden Brief Writing Award goes to Stacy Kim. For the best brief written in the 2026 Spring Semifinals Round of the Marden competition, the Marden Best Semifinal Brief Award goes to Rosie Coffey. And for the 4 students who have advanced to the final argument tonight on the basis of a superior spring semifinal round performance in alphabetical order, the finalist awards go to Rosie Coffey, Aiden Farmer, Anna Kolash, and Micah Musser. If we can get one more round of applause for all of these competitors and their hard work. For the remaining and final award, the Orison S. Marden Award, which is given to the best oral advocate in the final argument round, our panel of distinguished circuit judges are currently deliberating and will announce upon returning from their chambers. Upon the clerk's instructions, once the judges are finished deliberating, we will resume the proceedings. Thank you.
Please be seated.
The Honorable Justices of the Supreme Court of the United States have returned and the court is resuming session.
Well, thank you all for coming, and it's a huge pleasure for us to come from all points of the country. NYU is very generous, and your dean, I think he had to go teach a class, but you should all know that he's a friend of many of ours. The judiciary is deeply appreciative of the work your dean does, and he's a very talented scholar. To the Moot Court Board, this was my most challenging problem. This is not an area I know and deal with, even though the Eastern District of Louisiana gets a lot. So MDLs do come up to us. I thought the problem was outstanding. So you had, choice of law, which is difficult. What do you call it? Collateral estoppel, issue preclusion, offensive non-mutual, what? What's the right term? Issue preclusion, okay, well, Professor Zakharov said that's the answer. And then you wrapped the Fifth Amendment in and all of that around the enigma of MDLs, mass tort problems, case management issues, so a terrific problem. And I'll also say, in my opinion, you gave us the best memorandum of law that I've received. I don't know if that's the same set of authors, but you heard I was able to ask quite a bit of questions about scholarship because it was not only case law, but you gave us a great deal of access to the scholarship. And then I need to call out one of you. Who is it that was responsible for this script? Because it's 6 pages of what we were supposed to do, right down to every minute. I do officiate quite a few weddings of my law clerks, and they give me wedding scripts, but whoever wrote this is going to be a good law clerk. Because law clerks make judges look good, and it's this type of thing, right down to 502, do this, 503, do this. But most of all, the finalists and all NYU participants that were in the moot court getting up here, wow, I think this really showed NYU excellence. You are superb. Your friends and families who are here must be very impressed. We were. If you were arguing in the Fifth Circuit, you would have dazzled us. And I really mean that. Whenever I do moots, but especially at elite law schools, the talent could walk right into intermediate appellate courts and do superbly. Part of the hardest thing I think to do, so I'll just talk for a minute. We'll get to the selection we had to make, and it was very difficult. But first, just giving you constructive critiques. One thing that really impressed me about all of you, and it's hard to do in the Supreme Court, is to get out the sort of equities and the fairness. The underlying story is Harkonnen just a huge poisoner that's trying to break its bargain, or is Paul, the petitioner, someone who himself slept on his rights and just wants to piggyback on these 2 bellwether trials? You all heard the story, but very subtly, without being cruel to the other side, you were able to interject your sort of lens. That was impressive. None of you had what I call a chutes and ladder moment. It's a game that in my childhood we had. You climb up the ladders, but every now and then you get a chute and you go all the way to the bottom. So in some oral arguments, there's a question, there's just a gasp, and the lawyer just doesn't know it. And I think of that as a chute moment. None of you had any of that. You were all terrific. One of you saved me when I was asking a question about the other lawyer's side. I forget who that was. Who wants to admit that? Name? Rosie? Yeah. You. That's really difficult to do because you dignify a judge even when the judge is totally wrong. And the best lawyers do that. So let's see, just going in order, not in order, actually, Aiden. Where's Aiden? Yes. Okay, you were respondent, second issue. I was impressed by how you gave us, at the end, you had a limiting principle. You said, this will not eliminate issue preclusion in all cases. And you were able to, you started with Parkland, which I guess was a strategic choice to sort of amplify the picture of unfairness. And then you were able to go into such granular detail. That impressed me in terms of why it's so unfair in this particular situation. So your tactical decisions were very obvious. You got into the jury instructions and into the facts. I think the constitutionalization question is more difficult, and we got to that a little bit at the end. Micah, petitioner number 1. What I sensed that one of the things you really wanted to do was warn us, don't disrupt the MDLs. And so predicting a danger is very good. And you did that wisely, and you amplified repeatedly, and you brought that same theme up in your rebuttal. right? So it was a melody. On my court, a predecessor judge that I never was able to sit with, Alvin Rubin, said, you know, you're a great advocate when you sort of, your argument creates a melody that judges then want to sing in the shower. Now, I don't sing in the shower, but I came away really remembering that because it was your principal argument in rebuttal. Don't disrupt what's working really well. Let's see, Rosie, well, I've already thanked you for saving me. All of you were remarkable with what I call eclecticism. In other words, the facility with scholarship. I think I asked 3 different scholarship questions. Every single lawyer I asked knew it. Yours was the Metasplit article, yeah. But all of you were that. One quality I think lawyers do really well is they convey expectancy. In other words, they truly expect to win. You're representing a big corporation that's poisoned a lot of people. And yet at that podium, I had your utter expectancy that you should win. And you were very jugular. In fact, you shifted the dialogue to the petitioner who was at fault, right? And that was your heavy emphasis on what had been surrendered by the petitioner. So those 2 words, maybe retain that same expectancy you have, but also the ability to be jugular without harsh words. Anna, these are just my observations. And maybe, again, this will just reflect my age, but you guys know the radio show Click and Clack? Okay, I really felt you want to strive to have a conversation, utterly responsive. And I was trying to be a little aggressive with you. So I threw the statistics question at you, you knew it. I threw the Framer question at you, you rebutted that. And then the Curry footnote. So, but each time it was extremely conversational, which is an ideal type of oral argument. Every question, you receive it as sort of an invitation, and then you're very fluid in response. So, and the 2 of you who did rebuttal arguments, 3 minutes is extremely hard. So you were really good to be surgical. 2 points. I don't remember specifically, but it's what I call the last word. And it's sort of agony to have to listen to the last word, isn't it? It's the last, but you both did superbly. So I was just so impressed all around.
Okay, so I'm just gonna give a very general comment so that you guys can get along with your next things. But to echo what Justice Higginson said about a conversation, I do think that that's the art of oral advocacy, is trying to figure out a way to engage and have a conversation and not be afraid of the questions and really want to hear what the judges are having to say, because that gives you the only peek you're going to get into what their thinking is and the only chance you have to try to influence them. And so my comment is just basically on that point of, I noted in each one of your presentations a really good example of you doing that. So Micah, I think at one point you were asked a question by Justice Childs, and then you moved on to, maybe it was me, I don't know, and then you went and referenced back to Justice Childs' question, right?
Yeah.
Like you're holding the whole picture in your head, and that is really impressive, and not very many lawyers can do that, as it turns out in the world. Anna, I think at one moment you forgot a question because she asked you 2 in a row, and sometimes people freeze and then they can't move on or can't gather their thoughts, and you didn't do that, and you kept making the point, and then you came back to it, and again, that shows a maturity and a judgment, and just like, I'm here to do a job and represent a client, and I really respect people who can do that. Rosie, I thought at one point you were dealing with a double team where 2 of us were kind of being aggressive with you and sort of back and forth and back and forth and back and forth, and I thought you handled that really well in terms of your composure and your tone, and you didn't get irritated, and sometimes, I'll tell you a story. Recently in an en banc argument where I was on the panel, I was sort of aggressively questioning this lawyer because he didn't want to answer and he didn't want to be pinned down about this point. And I kid you not, at one point he was like, Your Honor, can we just move on?
Ooh, no.
I was like,
Wow.
No, we cannot just move on.
Oh
So,
my goodness.
so you handled that with a lot of grace and also just like, intelligence, right? Like you're keeping your arguments in mind and keeping the message that you need to make in mind. And Aiden, I thought you handled great my sort of gotcha question at the end of like, you would be arguing a different thing if you'd lost all those bellwether trials, right? I thought you handled that super well. So again, each of you had moments in your presentation that just showed not only a depth of intellect and understanding of this case, but a sort of maturity in terms of being able to argue the case, which I really appreciated. The last thing I'll say is on Aiden, and I don't know how this works in terms of the competition, But I think we were all ready to like argue with you about the due process clause and how you did that in terms of you were asked right out of the gate, like, which is your lead argument? You've got two arguments here, and you clearly indicated what your lead argument was. And that is perfect for practice. Like, I really appreciate a lawyer, because sometimes we recognize that lawyers have to make arguments that maybe their clients are very invested in, but the lawyer understands that it's not going to win the day or whatever reason, right? So lawyers gain a lot of credibility when they do the kind of thing you did. We were a little bit like, wait a minute, but that's an issue in this case, right? So I just wanted to give you that feedback of like, that is what good lawyers do out in the world. And so I don't know how that fits with the moot court situation, but as a real lawyer, that's a great thing to do.
Thank you, and thank you all for the opportunity to be here. And again, I want to echo about the outstanding materials and prep and, just really getting us ready here. Some of the general comments, too, is that I felt like you all really, really, really know your case. I mean, just to be able to get to the record and come from all sides, and, sometimes we're double teaming and doing things like that, but everybody was just so comfortable. So that feels good, because when you come before the court, we don't want to feel like we're intimidating you. We're just trying to get to the bottom of the information so we can know how we're going to write this. And so I saw very few even looking down, just with respect to their notes. Another thing that I like is that questions on practical implications, because I'm always thinking about not just what's the answer, but how do we write this? How do we make sure that people will follow this as precedent from other for years to come? But I'm also concerned about unintended consequences. So we try to get into the weeds about those particular cases, because you've got one plaintiff here who's direct filed, but then that's all we have. We don't have the rest of the other information in the case, and so we got to know, like, is this the right time for this rule? How far do we go? How far do we clarify in that regard? You all had really great anticipation of questions. Like I said, really know your case. I felt like, Micah, too, you didn't get off, you allowed yourself to get off script. If we're asking you a question, it's about what we want to know, because we might have our minds made up, or we're trying to convince another judge about something. So you're not just staying on script. You're answering the questions to make sure we're comfortable with, whatever responses are and how we're trying to convince ourselves on that. And so all of the above comments that I said before that certainly apply to you as well. Anna, you did a great job with the 70s question about the history of the law, because I really thought he was just throwing you something. I was like, whoa, she came back on that. Yeah, and very poised. And then I saw this with a lot of you too, but joyfully here, like, it's not intimidating, like, hey, I'm ready, I'm coming to the court, and this is what an opportunity, and to be there for your client, and you're just embracing the situation. And I've become good friends with her, Elizabeth Prelogger. Phenomenal. If you can go back and listen to any of her arguments, she's that way. She can just be getting beat down by the Supreme Court. You wouldn't know it. She's just so friendly, and just how she relays the information, doesn't get intimidated, and doesn't, it's not snarky back. And I thought on your rebuttal to the great separation between class actions and MDL, because people do get caught up into not making that distinction in that regard as well. Then with respect to Aiden, the question about the metrics, really good response there, and just tying it all up between time, geography, and separating all of the kind of scientific facts in the case, to let you know that there are some distinctions there, that benefit your client. And then, of course, the writing rule. I'm always looking for, what's the limiting principle? How do you want us to carve this out? Because it's hard. I mean, especially in a case where there's got so many plaintiffs and parties and all of that. How do you really carve this out, and we're not here again in a year, essentially in that regard. And then, Rosie, you're very conversational. You were easily invested in your facts. And I think one thing that you might have done differently than everybody else too was there was a lot of focus on the law, obviously, because it's a choice of law question, but you never left your clients, like you never left who they are, how this is impactful on who is actually before the court. And sometimes, judges can get so involved in the case, but forget that there's an entity or a person on each side of the V. And so I felt like you just never left that. And then also the relief. You know, you all were very clear about what are you asking us for, you know, because you can just keep arguing, going back and forth, but you always have to be thinking about the relief, and not only thinking about it, if you listen to the questions and things are changing, sometimes that gets changed in your oral arguments. So you just keep zoning in on that because we're trying to narrowly write, and you have to help us get there, you know, with your limiting principles and how we're going to deal with the relief, and particularly if something's going to get remanded, what are going to be the instructions to the lower court?
Okay, well, you've heard all the superlatives, and it was so close that we were divided, but courts have to decide hard cases, and in the end, we gave the oral advocate distinction to Anna Kolash.
Hi again, everyone. I apologize that
No,
my
that's
back
fine.
is
It's
to you.
Where are your crutches?
First, I want to thank our wonderful panel of judges, Judge Higginson, Judge Forrest, Judge Childs. Thank you so much for Thank you so much for taking time out of your very busy schedules to come to NYU and to judge this round of oral arguments, to spend time getting to know our Moot Court Board members and providing insight on appellate advocacy to the finalists and to this room of students, friends, family. I'm speaking on behalf of the Moot Court Board and all of our audience members here today when we're so grateful for your participation, your thoughtful questions, and the feedback that you've provided to the competitors this evening. The feedback here is not valuable to just the finalists, but it's valuable to all of us who aspire to one day be litigators and may one day argue in front of you in your courtroom. So please join me in one final round of applause for our judges. I also want to thank all of the competitors again from both the fall and the spring rounds of this Orison S. Marden Moot Court Competition. Like I mentioned before, everyone from both the fall and the spring rounds put in so much time and effort, and we have seen such tremendous oral advocacy and brief writing skills this year. Speaking for myself, it's always very inspiring and rewarding to see my peers so passionate about oral advocacy and improving their ability to be better legal professionals. So a big round of applause for everyone who competed this year. And I want to echo everything that the judges just said here tonight and saying congratulations to all of our finalists. You've all just completed what may or may not have been your first oral arguments before a panel of Court of Appeals judges, but I'm almost certain that it will not be your last. And we are all extremely impressed by all of you and want to congratulate you on your incredible performances tonight. I would also like to thank a few and all of the members of the Moot Court Board, without whom none of this would have been possible. First and most importantly, I want to thank this year's Marden executive editors, Alicia and Sung. Orison S. Marden Moot Court Competition is unique in the fact that it's not just 3 days of a competition, it's 3.5 weeks of oral arguments over the course of 2 semesters. And Alicia and Sung have both worked tirelessly during every single one of those weeks. And not only were they prepared to step in and fix anything for every single round, but they spent countless, and I mean countless, hours preparing for each round and editing the fall and spring Marden problems, assigning competitors to rooms, recruiting practitioners to serve as judges, grading briefs, calculating scores, so on and so on. I can honestly say Alicia and Sung did everything in their power to make this year's Marden competition one of the best, if not the best, Marden competitions that NYU has seen in recent years. And I truly could not have asked for a better pair to work with. So, big round of applause for them. I also want to thank our 2025-2026 Orison S. Marden problem writers, who we have heard tremendous things about tonight. Maya Shamra, a 3L casebook writing and research editor of the NYU Moot Court Board for her incredibly written fall Marden problem. So round of applause. And to Chris Afoa, also a 3L casebook writing and research editor and one of our managing editors of the NYU Moot Court Board for his equally incredible spring Marden problem. They both worked closely with our casebook team and the Marden executive editors on their record and bench memo, finding a very interesting circuit split and creating a unique set of facts to keep the competitors and practitioners engaged in this year's Marden rounds. I would also like to thank the Moot Court Board staff editors who helped edit either the spring or the fall Marden problem in some capacity, including Lily Van Petten, Sabrina Ruck, Philip Keisler, and Gabby Santa. Over the course of both the fall and spring rounds, we received so many compliments, as we've seen here tonight, on the quality of this year's problems from practitioners and competitors alike. So big thank you to them. I also want to thank all of the members of the NYU Law Moot Court Board from serving as clerks in each round, runners providing a helping hand to Sung, Alicia, and I in the middle of rounds, recruiting practitioners for judging, filling in at the last minute to judge when those practitioners fell through, grading briefs, or just offering support as competitors along the way. I can honestly say, and I think Sung and Alicia can say too, that bringing to life this year's Marden competition has been one of the most rewarding experiences of my law school experience, and it could not have been done without each and every one of you. So, round of applause. And then lastly, I want to thank the Dean for his opening remarks, Katie Shirley, Alana Kent, and the Office of Student Affairs for their support over the course of the year, and all of the staff here tonight and at the pre-finals reception who have made tonight run so smoothly. And then thank you to everyone in the audience here tonight. I hope that you've enjoyed watching these outstanding oral advocates and hearing from an incredible panel of esteemed judges. We hope that you'll join us next year to watch and celebrate all of the future Marden oral advocates. Thank you and have a wonderful night.
It's been
All
so
rise.
wonderful working with you all.